Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal law here, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry on our channel, Law Offices of Cross and Associates. This has to do with rape between minors. Let's see here. My wife and I adopted a child when he was 5 years old. He is now 17 and has been raping our daughter since she was 6 years old. She is now 10. Well, normally if he was an adult, and let's say he had been raping her while being an adult, I would say that this would be a violation of Penal Code Section 288.7. This is a major felony that would carry up to 25 years to life for each offense. However, there's a bit of an issue with him being a juvenile, and he had been a juvenile this whole time. He's still a juvenile. See, here in the state of California, first of all, any kind of sexual penetration of somebody who's 10 years or younger, that carries a 25-year life sentence, Penal Code Section 288.7. They could also file 288.5, which is continuous sexual abuse of a child, if there are more than 3 occurrences during a 2-month period. However, in this circumstance, because he is a minor, there's a bit of an issue, at least with regards to the sentencing. Obviously, he'd be looking at lifetime sex registration, of course, under Penal Code Section 290. But within the last few years, policy has been put in place here in the state of California based off of I believe it was a state Supreme Court ruling indicating that a life sentence it'd be considered cruel and unusual punishment for a juvenile. Therefore, they have essentially put a cap of 25 years on juvenile cases, where basically juveniles can apply for parole after 25 years, and generally speaking, they would be released on parole. So nowadays, somebody like this 17-year-old, if he is found guilty of multiple counts of 288.7, more likely he would have to serve 25 years, 25-year sentence, and then after the fact he would be paroled. But the other issue that comes to mind is whether or not the parents knew that this was happening, or did they report it immediately. The reason is because, let's say the parents hypothetically knew that something like this was happening and kept their mouth shut for a long time. They could file charges, the DA could file charges against the parents for a violation of Penal Code Section 273AA, which is child abuse, cruelty to a child, which carries up to 6 years in state prison, or contribution to the delinquency of a minor. But barring that, assuming the parents found out about it, reported immediately, this would be a situation where this kid, the 17-year-old, would be facing a potential 25-year sentence, and he would be able to apply for parole as soon as he was finished serving that sentence, regardless of that. If you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. I do want to make one last note that in this situation, it would be a good idea to have the kid psychologically evaluated under Penal Code Section 1368, because if the kid is so messed up mentally that he cannot appreciate or could not appreciate the consequences of his actions, nor could he assist in his own defense, it's very possible that he could be sent to a hospital as opposed to having to stay at a juvenile facility. Regardless, in the next video that we're going to be making, the subject matter in question is going to have to do with driving under the effects of marijuana. So we'll see you in the next video.